Mr. Victor Giwa joins us now to give legal perspective to the issue of the Chief Judge of Benue State and the issues around it. Just as a background, we've said it before, there was a House of Assembly voting to remove the Chief Judge based on some allegations leveled against him. But the NJC has come out to say, no, you don't have that right. Look at the laws, it's very clear. You can't really move forward back and forth without us. And they say he remains the Chief Judge. Let's bring in Mr. Giwa. Mr. Giwa, thank you so much for coming on the program.
Yeah, thank you so much for having me.
From where you sit as a legal practitioner, looking into Benue State, what do you see playing out here?
Well, thank you very much. Like your introduction, I'm a legal practitioner. I'll be looking at it from the prism of the law, of the Constitution. So I will be speaking directly on the Constitution and try to make sense of what the Constitution says. Like Jerome Frank, one of the best brain in the United States of America, he said, "Let us elucidate the obvious before we obliterate the obscure." Let us elucidate the obvious before we obliterate the obscure. So let us look at the sections of the Constitution and try to make a sense out of what it says. Now, firstly, the removal of judicial officer is contained under Section 292. And so as a lawyer, whatever is happening in Benue State, I will be looking at it from the prism of the Constitution. I'm not from Benue State, so I'm just a lawyer. Now, Section 292(1) says that the judicial officers shall not be removed from their office or appointment before their age of retirement, except in certain circumstances. That is Section 292(1). It now goes on to have a paragraph, paragraph A. And paragraph A has two subsections, Roman figure I and Roman figure II. There was a mistake on the grading. So Roman figure I starts from the Chief Justice of Nigeria. He said, so these persons as follows, except, if I read it again, he said, a judicial officer shall not be removed from office or his appointment before his retirement age, except in certain circumstances as 1, for the CJN, the President of the Court of Appeal, he listed paragraph 1. Paragraph 2, which is the area of concentration in this case, he said the CJ, the Chief Judge of the State, the Grand Cadi of the state, or the President of the Customary Court of Appeal of a state, by the governor, acting on the address, supported by 2/3 majority of the House of Assembly of the state, praying for the removal, as a result of him not being able to, his inability to discharge his function or appointment, with unreasoned sending from infirmity of the mind or of the body, or misconduct, or contravention of the code of conduct. Now, that is paragraph A. And I think this is where the confusion is coming from. Paragraph B of Section 292 now made a very interesting comment. And if you read paragraph B, it says, in any case, and that is where I think people have misinterpreted these two sections. Now, there is a paragraph A that has enlisted what if the removal of what he feels is the judicial officer. He now went further to say in paragraph B, and he started with a phrase, in any case, other than those in which which paragraph A does not, the paragraph A subsection applies, other than those that subsection A applies. So the paragraph in section B says that while you can remove the CJ as stated in paragraph A, 1 and 2, section B says, in any case other than those in which paragraph A subsection apply, the president or in any case the governor shall remove the judicial officer on the recommendation of the National Judicial Commission. Now, in the interpretation of statute, there's a provision that says expressio unios ex exclusio ulteriors. The express mention of one is the exclusion of the other. So section 292A, paragraph 1 and 2 is an independent section. So it has stated that for the removal of a chief judge of a state, the president of the grand county of a state, and the president of the customary court, that the governor of a state, in an address supported by 2/3 majority, can remove the chief judge. So that is what paragraph A is saying. Paragraph B is not saying that for those, because chief judges are not only the judicial officers. The chief justice of the Federation, president of the Court of Appeal, chief judge of the state, grand county of the state, president of the customary court of the state are not only the judicial officers. And a judge of a state high court is a judicial officer. So section B now started dealing with how you can deal with those ones that have not been mentioned in subsection 292A, and that is why the starting paragraph in paragraph B says, in any case other than those in which paragraph A subsection do not apply, that paragraph A subsection applies. In any case other than those that paragraph A subsection applies, this is the way to remove them. So it has distinguished between the removal of a chief judge and a removal of other judicial officers that are not in the position of the chief judge, grand county of the state, or president of the customary court of appeal of the state, as stated in the paragraph.
So the Constitution is quite clear, and there's no basis for what state assembly members are hinging their decision on. So in summary, there is no constitutional crisis in the Benue State Assembly, as we may assume, over this purported suspension of the state chief judge. We'd like to thank you very much, Mr. Victor Giwa, Mr. Giwa Victor, a legal practitioner who has joined us from our Abuja studio on this very important conversation. Thank you so much for your time on the program.
Thank you so much for having me.
And so from here, we go to yet another very interesting topic. It's a story of resilience in the face of very, very challenging circumstance. We have the inspiring journey of a young man who came from insurgency to becoming an aerospace engineer. Stay with us for this conversation. We'll be right back.